This is All India Radio. In the program Spotlight, now we bring you Year-End Series exclusive interview with Union Minister Shri Kiren Rijiju on achievements and key initiatives of the Ministry of Law and Justice. The interviewer is Omvesh Upadhyay, AIR correspondent.
In this exclusive Year-End series, we have with us Union Minister of Law and Justice, Shri Kiren Rijiju. Welcome to the program, sir.
Thank you.
I will begin the interview keeping in frame your public-centric approach in smoothing the judicial system for all, or I can say ease of justice. This year, the Department of Justice launched a new Divyang-friendly website to provide citizens a one-stop platform. Can you please elaborate more about the website and how it is making the judicial system inclusive for all?
See, Indian judiciary is very well known that it is very robust system, but the question is how much people are accessible to the Indian justice system or Indian judiciary. All our platforms, systems, procedures, process, everything has to be people friendly. That is why we created certain websites, certain mobile apps which are not only accessible to everyone but Divyang friendly also. This can be easily interpreted and conveyed people from Divyang community and also ensure that they are equally accessible to this system.
Indeed, very rightly you said that the ministry is trying to make justice accessible to all. I remember in July, NALSA launched the initiative Release UTRC at 75 for identifying eligible under trial prisoners and recommending the release of fit cases to the committee. Sir, how significant a step this was to fasten the system? Second, address the pending cases. And thirdly, bring ease of justice.
See, first of all, during this Azadi Ka Amrit Mahotsav, we are celebrating the 75th year of India's independence. We want to take certain steps to ensure that those people who are waiting for the justice for a long time are given a fast-track justice. One of the important matter here is the people who are languishing in the jail for long time due to lack of the legal services or legal aids. There are large numbers of under trials in various courts of India, and our courts are very crowded. It has gone beyond its initial capacity. So we have made an announcement, and during the last Chief Justice, the Chief Minister's Conference, and during Law Minister's Conference also, and during the NALSA's special meeting also, Honorable Prime Minister also raised this issue, and I had personally followed it up, that the district judges head the review committee. So the under trial review committee headed by the district judges should be made more active so that they can immediately go for the trial and release all those people who have served out their tenure. They have no reason to languish in the jail for a longer period. And for that, NALSA and from various platforms, we are trying to give them legal aids and services. Right now, we have received a very good report that large numbers of under trials have been released so far and many more will be released in the days to come. The ease of justice is a larger concept, whether from the constitutional matters where we go for large constitutional changes to make life of the citizens easy, or for ease of living like we change in commercial acts, various provisions in the various commercial laws, and to remove certain provisions of law which are unnecessarily creating troubles or hindrances in the common life of the people. Some of the compliances which are not necessary, for example, the attestation. Now it is self-attestation. Earlier you have to go to the gazetted officer for attestation. There are many provisions like we have started decriminalization of various penal provisions. Make it simple. There are various laws which are known as archaic laws or the provisions made during British time. So when India is an independent country, we govern ourselves. Nobody is our master. So in that context, our laws are to be very citizen-friendly and citizen-centric. That is why we have gone through major provisions of all the existing laws. And we have already removed 1486 archaic laws. All those laws which are redundant, which are not required anymore. And I have recently, in the last winter session of the Parliament, introduced 65 laws to be removed. So the amendment bill has been introduced and this will be removed in the next session of the Parliament. So ease of living means our laws, the regulations are to be citizen friendly. That is our approach and we are succeeding in that, and Prime Minister is very clear on that government should be intervening in minimum possible way in the life of the common people.
Indeed, and when we listen you talking about this, we know that it is not only the talk, but we are witnessing this in action. Moving further, I would like to know that when we talk that India is continuously climbing the ladder to become an economic superpower, to represent this new India, India International Arbitration Center is determined to conduct other forms of alternative dispute resolution besides arbitration as well. So sir, I want to understand from you how significant will it prove to make India the arbitration hub of the world?
One thing you have to understand is India has the largest number of litigations in the world. We have highest numbers of pendency in the world. Now when our pendency is close to 4 crore 90 lakhs, we have to think about alternative dispute resolution mechanism. India has long tradition of mediations. We call it Madhyastha. So since ancient time we go for mediations to settle various disputes amongst the parties or communities. So other than the formal court procedure, we need to give lots of importance to alternative dispute resolution mechanism. So for that, we already have brought many changes in the Arbitration Act. I have already introduced the mediation bill, which got little delayed due to the scrutiny made by the Parliamentary Standing Committee. And also, we have created this India International Arbitration Center in Delhi. We have many arbitration centers in the country which are working in a very ad hoc manner. We want to institutionalize the entire arbitration system in India so that we can attract the global community. See, India is today the 5th largest economy in the world. Naturally, our economy is going to attract various business houses and stakeholders across the world. That is why our system has to be robust, because people must have faith in Indian judicial system or India's arbitration centers. We have taken lots of steps on that direction, and we are establishing ourselves as a center of international arbitration.
Moving further, I would like to know from you that under the National Mission for Safety of Women, the Union Government is implementing the centrally sponsored scheme for setting up 1023 fast-track special courts. Sir, how is the Ministry of Law and Justice prioritizing women's safety?
Women's safety has been a priority for our government, and it has to be a priority for the society as a whole. In 2018, we brought the Major Criminal Amendment Act in the Parliament. I was Minister of State for Home those days, and I was the one who introduced the bill and gave the deliberations in the House. After that criminal amendment bill was passed, certain provisions were laid down, and one of the important provisions of that act was to establish the fast-track special courts. Besides changing the various stringent legal provisions like death penalty and all, we need to ensure that the trials also has to happen fast. We have asked for establishing the fast-track courts in all the states and UTs. See, fast-track courts and fast-track special courts, these are two different things. Fast-track special courts is only for the crimes against women and children. So this POCSO Act also established various POCSO courts, and those amongst the fast-track special courts, some courts are identified as POCSO courts. Now some states have performed very well, but some states like West Bengal, they could not take it forward. I had written to the Chief Minister of West Bengal, and through my Secretary Justice also, the concern was conveyed, and I have also asked the Chief Justice of Calcutta High Court to take it up with the state government so that the fast-track special courts can be established adequately in the state of West Bengal. There are certain difficulties, but we cannot take excuse of anything in terms of providing speedy justice to the woman. The crimes against women is one of the major yardstick to see how much a society has progressed. If a society is progressing very well in economic yardsticks or political inclusivity, but the safety and security of the woman remain a challenge, then it must be a concern for everybody. Without the progress of the woman, society just cannot progress in real terms.
Indeed, you have been very vocal about this. You are firmly advocating for this. The major reform in the collegium system, per se a more broad-based, transparent and accountable system. Sir, where the current collegium system lacks and how the reform will improve the system overall?
The main problem with regards to the appointment of the judges is lack of understanding amongst, I can say, judiciary, to some extent the other stakeholders, the spirit of the Constitution. Indian judiciary is well respected because Indian judiciary is independent. Any decision given by the court is final unless it is overruled by the larger bench or higher courts. Supreme Court of India is final arbiter of any matter. If the Supreme Court has passed a judgment or given a direction, that becomes law of the land. The question is, since courts are final, should the judges be involved in appointing the next judges? The Constitution has been very clear that the appointment of the judges are to be initiated by the government, by the executive. The constitutional provision is very clear that the President of India shall appoint the judges in consultation with the Chief Justice of India, and for the High Courts, consultation with the Chief Justice of High Courts, and there can be some due consultation with the stakeholders or consultees like governors, chief ministers, and all. Consultation means wider consultation, and consultation also means effective consultation. It's not mere formality to seek opinion. So, in 1993, in the second judge's case, when the Supreme Court with a full constitutional bench undone the constitutional provisions and created a collegium system. Now, this collegium system is functioning since then. My basic question and concern is, judges are there to delivery of the justice from the benches. Judges are extremely busy to study the case and to give the award. If judges are involved or they are given the job of identifying the next judges, that is basically administrative job. Now, if judges are too much involved in administrative works, it will definitely have an adverse impact on their duty as a judge. So, the administrative process is not the job of the judges. It is up to the government. But today, the judges who are in the collegium and all other judges are also directly involved in the appointment process, because the collegium system has made the senior judges extremely busy in picking up the names of the next judges to be appointed. So the constitutional provision was very clear that the judges should not be involved in the appointment process at all, except the consultation to be carried out by the executive, that is basically to seek their opinion.
Moving forward to the concluding statement, I would like to know from you, sir, that from December 1, India formally and officially held the G20 presidency. How do you see India's G20 presidency, and are there any special efforts made by the Ministry of Law and Justice in this regard?
See, G20 is not a government program alone. G20 is national call to rise to the occasion and take the responsibility of the presidency of G20 by India as a nation. That is why Prime Minister Modi ji has clearly spelled out how India would host the G20. Government of India will take the lead role. State governments will be the equal partners. All major organizations who are stakeholders will be taken into confidence and given the role of participation. More importantly, the citizens of India must be involved. The ownership of hosting the G20 summit in India has to be an occasion to showcase India's heritage, India's inherent ability to showcase our soft power to the global community, and also to drive the global agenda, to drive the important concerns which India thinks is for the global community, for the humanity. So, you all know very well Prime Minister's very unique way of putting things and involving the citizens. All the ministries in Government of India, we are all stakeholders. This is a whole of the government approach, not foreign ministry or the concerned ministry or subject where you will have the summit meeting of the ministers of the concerned department. We are part of the same group. So, Prime Minister's design, his dream, his vision is very clear before the nation. Today, India is in the center of the global attention.
And absolutely, without a doubt, India will lead the world with the motto, Vasudhaiva Kutumbakam. Thank you so much, Mr. Rijiju, for joining us today in the conversation. It was indeed a very insightful conversation.
Thank you. It's my pleasure to sit with All India Radio. Thank you very much.
You were listening to Year-End Series exclusive interview with Union Minister Shri Kiren Rijiju on achievements and key initiatives of the Ministry of Law and Justice. The interviewer was Omvesh Upadhyay. AIR correspondent. This program was produced and presented by the News Services Division of All India Radio.